Thank you very much for very comprehensive, very detailed explanation how we should pattern AI patent. Thank you for staying with us in 2022 World WIPF, the panel titled Artificial Intelligence and Intellectual Property. Our next speaker is Mr. Chirag Bansal. He would like to talk about the Indian regime related to IP. Mr. Chirag Bansal is working with LX Devil Corporation in the capacity of patent attorney. Chirag is a registered Indian patent agent and holds a master's degree in computer science and engineering. Chirag possesses a rich experience in the field of patent and is responsible for patent prosecution and drafting, representing clients in oral proceeding before the patent office and handling contentious matters. Before I pass the floor to Chirag, I would like to introduce you another application for AI. It's already very mature. We apply AI and big data support on due diligence. I would tag the recent case. It was filed 2002, June 10. It's Knowledge versus Micron technology. I would like to demo you how we can use AI for due diligence. For the portfolio status and sustainability, we can just simply enter a patent list or search a company name. Then it will summarize the status, value, and quality of the portfolio, which facilitates our assessment. Patent Crawl over due diligence this tool to immediate the regional coverage and status of matters portfolio. In addition, it can also provide the trajectory, how many active patent that was sustained in which jurisdiction if analysts keep maintaining. Patent quality and patent value assessment, we can do the comparisons side by side based on the class, both for analyst and micron, as you can see here. And we can predict the relative potential invalidation patterns, because for those pattern with with poor quality, they were most likely to be invalidated. And how similar pattern is to pattern that overcome examination. Predict the relative potential for monetization. So based on how similar the pattern to the pattern will litigate or transact. The modern tool, AI tool, they could support due diligence beyond a macro view, and they could specifically categorize the quality issue of each pattern, and they could be instantly examined. For example, 88% of patents in next portfolio have US member challenge with eligibility or novelty issue during the prosecution. And there are 25 families, around 59.5% have the US member challenge with novelty issues. So it's just few clicks, and then you can figure out the eligibility, novelty, non-obviousness, and indefiniteness, different grounds for the weaker patents, where you will be most likely to success on your patent due diligence, monetization, infringement suit, whatever. And we can also use due diligence tool offered by Patent Cloud to conduct the technology followers as a potential licensee or buyer. So you can easily find out the patent who is following you, and so for you to handle the licensing later. And you can export a report So it's very convenient. So this is, you can have this few clicks. For example, they will spot the potential buyer or licensor who are technically follow your patents. And then, for example, the family 450346169, and they will include this litigation suit patent 060. Has not only found have the novelty and non-obvious prior art of micron during the prosecution, but also SK highness pattern, NVIDIA pattern. So you can further obtain a macro view while enabling a case specifically assessment by entering just the pattern list or search company name. So AI big data, they support due diligence, and the due diligence tool they could give you a very brief, comprehensive chart easily for you to make your decision. So you can further dig out the potential target. Apart from the micro, you can do something else. You can sue more companies, and you can find your potential licensee or buyers. So now I pass the floor to Chirag. Chirag, the floor is yours.
Thank you, Professor Wang. And thank you all for joining. My name is Chirag Bansal. I am associated with LS Davar & Company, one of the oldest and largest IP law firm in India. So this year 2022 is special for us because we just turned 90 this year. So I will be speaking on the artificial intelligence and the Indian patent system. I will walk you through the AI ecosystem. In India, guidelines for examination of computer-related inventions in India, prosecution of AI inventions, and at last I will touch upon ownership of AI inventions. Starting with the AI ecosystem, according to the latest government AI Readiness Index, India has the 4th highest number of technology unicorns after the USA, China and the UK, and the 3rd highest market value for technology companies in the Forbes Global 2000, which demonstrates India's strong interest in the adoption of AI. Data from the Stanford AI Index 2020 discloses a steep increase in the publication from Indian researchers on AI-related topics from 2015 to 20. Again, these statistics indicate the Indian government's commitment and efforts in promoting AI in the country. Recently, Indian government has also set up a central knowledge on artificial intelligence to create a unified AI portal ecosystem. This India AI portal is driven by the Ministry of Electronics and IT, National E-Governance Division, and National Association of Software and Service Companies, which they released a report in 2020 that highlights that India ranked 8 in terms of AI patents filing for the year 2020. Over 500 plus AI patents were filed in the last decade, and surprisingly 94% of them were filed in the last 5 years. 63% of the granted patents belongs to MNCs. Consumer electronics, personal computing device, and the healthcare are the leading vertical force areas. Machine learning and computer vision are the most popular AI techniques used. Next, please. So now coming down to the patent application related to the AI inventions, the inventions technologies which are based out of artificial intelligence in India are examined similar to that of computer-related inventions, CRIs. The latest guidelines which are issued for the examination of computer-related inventions are more relaxed compared to the old version. As per the old guidelines of the CRI, if the contribution lies in the field of computer program, then the examiner check whether it is in conjunction with a novel hardware or not before proceeding to other steps to determine the patentability. So thus makes requirement of novel hardware mandatory. The latest guidelines issued for the examination of CRI has now done away with the requirement of the novel hardware, and the patentability criteria is eased out. The revised guidelines focus on substance over form instead of the novel hardware requirement. Can you go next slide, please? So speaking on the prosecution of the AI-related inventions in India, as I just told, inventions based out of AIs are examined similarly to that of CRIs in India, and the invention should satisfy Section 3K requirements, which restrict computer program patentability per se. So there have been concerns over the correct interpretation of Section 3K, and this was settled down in a writ petition filed before the Honorable Delhi High Court in the case of Farid Alani. The writ petition was filed. To challenge the decision of the appellate board denying protection for the invention, title, method, and device for accessing information sources and services on the web. The Delhi High Court has laid down the patentability criteria and quoted. Next, please. That it is very rare to see a product which is not based on a computer program. Whether they are cars and other automobiles, microwave ovens, washing machines, refrigerators, they all have some sort of computer program inbuilt in them. Thus, the effect that such program produce, including in digital and electronic product, is crucial in determining the test of patentability. So now the position is much similar to the European laws, that if there is a technical effect, then the subject matter will be considered for patent in India, even though it is related to the AI. And definitely this is a very welcome decision of the Delhi High Court, which is paving a very smoother way for the AI related inventions in India. Next, please. Yeah, while dealing with the prosecution of the AI related inventions, the Indian examiners tend to raise these three objections: that the claims are directed to the algorithm or computer program, they lack constructional features, or they are directed to a mental activity. So now how can we counter them? The most prominent approach is find a technical problem in your description, find a solution, and show the advantages. We can also try to link the advantages with some of the advantages which the Patent Office has already acknowledged in their guidelines of 2013, like higher speed, reduced time, more economical use of memory, etc. And if the examiner is focusing on the mental act, it means he is looking for some hardware features. Give him some. Whether it's display, processor, give him some. Next, please. Next. So speaking on the ownership of AI inventions, so under the Section 6 of the Indian Patent Act, a person, an assignee, or the legal representative of the deceased person can apply for a patent. The definition of person also includes government. Thus, the natural person or the government can apply for a patent in India. As of now, in the Indian Patent Act, there is no reference for the machine being named as an inventor. Although the DEPA's patent application has been filed in India, but it's still in the examination phase, and we are closely monitoring it. But as of now, it is under examination, so there are no updates whether they will allow it or not. Until the law is amended to include machine as inventors, the party will have to rely upon the contracts. In case of the dispute, the court will decide conflicts based on circumstances of the court and agreement in the parties. And as of now, as I told, there are no decisions from the courts related to the ownership of IP rights and AI inventions. This is all from my side. Any questions from the audience?
Any questions for Chirag? So if there's no question for this moment, shall we pass the floor to